All right, so morning everyone. I hope the audio and visuals are clear to you all. So the video is also streaming. I'm welcoming you all, my brother and sisters who are listening me. So as you can see on your screen that we are going to discuss the latest Supreme Court judgment, which is elaborating the various aspects of adverse possession. So what I am going to do in it, the importance of judgment, essential of adverse possession, even though I am also covering the various supplementary facts which are helpful for you. Who are the litigating lawyers? They can go in this way, and this judgment is really if you are dealing with the adverse possession. So let's begin with the judgment. Fine. So you can see the PDF file of the judgment. You can download it from the description section. I can elaborate it and put it in the description also. So this is the non-reportable judgment, but as all of you know that you can also mention the non-reportable judgment. It hardly matters for the sub judice or high courts or whatever district court you are practicing in. It is a non-reportable judgment. The appellant is actual plaintiff M. Radhesham Lal versus V. Sandhya. What I am going to do, I will let the supplementary fact, like factual aspect of the case. I just want to put the special emphasis on the important technical points, which is helpful to understand the basic concept. First and foremost thing, it is a non-reportable judgment delivered by the Honorable Lordship Abhay S.K. Oka or Abhay S. Oka. The judgment delivered by Supreme Court, that's why it is equivalent to the working and also a standard benchmark to get practicing. It was arises through an SLP of 2014. So I want to clear some basic fact and basic background. There are the three civil suits. Trial court rejected the plea, then High Court also dismissed suit. That's why the SLP arises. And in this SLP, the person Radhe Shyamlal, who is the plaintiff as well as appellant, and defendants are here respondent. Fine. So it is clear. Now, the basic aspects is related to the that plaintiff claimed plaintiff claimed an adverse position. So for us, it is important to know that what is the adverse position. What was the claim of the plaintiff? That he claimed an open, uninterrupted, continuous possession of a suit property. That is a parcel of land. It is a piece of land in which the plaintiff claimed adverse possession, and he also claimed that he resided there since from last 45 years. So he perfected his claim on the basis of adverse possession. It becomes important us to know the concept of the adverse possession, as well as he also claimed permanent injunction. So in the suit of the permanent injunction, you get the right against other that no one is going to interfere or enter in your property. This is the basic aspect of suit. Let's begin with the adverse possession. What is adverse possession first and foremost? Adverse possession is a kind of hostile possession. What is hostile possession? What is possession? If suppose it is a piece of land, you are the owner of the land, but you are also residing there. You are also residing there. Means this land is under your possession. Okay. The ownership and possession both are with you, But if another person come and claim this position, it is against you or adverse to your right. That's why it is known as adverse position, and we call it in a general language hostile position. Basically, hostile position is the denial of the title of the true owner. Means you are denying that the property titled over the owner, and I am denying it, and I am claiming my right. But the thing is, from where the adverse position come in the picture. So for this, you have to go to the Limitation Act, as all of us know. Limitation Act 1963. It puts some limitations, some bar, and Section 3 of Limitation Act explain that any court will not take cognizance, will not take cognizance of any suit. I am talking about any suit which is barred by limitation. So if there is any suit which will come in front of the court and it is barred by limitation, the court will reject it. Now come to the Limitation Act. Does Limitation Act also bar your right? There are the two things. One is a remedy, another is right. What is the difference between remedy and right? Bail is a remedy, jail is a punishment. Bail is a remedy, but freedom is your right. The essential question related to the Limitation Act, that is the limitation also putting a bar on your right? No. Limitation Act not bar your right. It only bar your remedy. Why I am telling this? Because it is connected to the Section 27. What is the Section 27 of Limitation Act? Section 27 of Limitation Act is is an exception of Section 3. So Section 27, it is an exception of Section 23. How? Because Section 27 is mentioning that after once the period is over, after once the period is over, the right to property extinguish. Right to property is your right, correct? It is not your fundamental right today, but it is your legal right. But once the limiting period or limitation period is over, you can also not able to claim your right over property. Section 27 is clear. If the person is failed to file a suit for recovery, I want to explain it a bit more. If suppose you are the owner of this property, but you lend this property on some other's possession, means you are the owner, but you are lending this property, and this property is with another's possession. After 12 years, you are not able to claim it. You are not able to claim your possession right back. So once a person fail, once an owner fail to suit, to file a suit for recovery of possession in 12 years, the right of that person will extinguish. It is clear? Extinguish. Now, what happened to the property? Once the owner's right extinguish, the property will left ownerless. Now, property will left ownerless, but it is not conditioned under the legal system. So, the ownership of that property will be transferred to the person who is under possession. Who is under possession? It is known as adverse possession. From where I'll get this 12 year? So section 64 and 65. Section 64 and 65. Under first schedule, there are the various type of suit and their limitations are also put over there. You'll go and get the idea. I am talking here about immovable property. Regarding the immovable property, the limitation period is 12 years. So adverse possession is clear, section 3 clear, section 27 clear, section 3, section 27, section 64 and 65 in first schedule. This is the adverse possession. Now there is one more interesting point. If we'll see the judgment, yeah, submissions. So the appellant advocate submitted that the learned senior counsel appearing for this, the original owner executed a will, executed a will, and the suit property be claimed on the will only if the probate or the letter of administration obtained. What is mean by letter of administration? So to understand this judgment fully, it is also required to have a glimpse of will. A is the original owner. Try to understand this concept. A is the original owner. If he executed a will, it is okay. If he executed a will, but if suppose A is the owner and he died without without writing a will, this condition in law is known as intestate. There are the two type of succession, testamentary and intestate. I am talking about intestate. So if suppose the owner died intestate, in that case, under Indian Succession Act 1925, there is a concept defined in section 2F about probate. What is probate? Probate is a copy of will. It is a copy of will after the death of the owner. It is a copy of will under the seal and sign of the respective court or district court, whatever is the competent court according to law. That court cross check this will, ensure the legality of will, ensure the correctness and genuineness of will, and then give its seal sign. After that, the executor of will or the person who is claiming his right by will get their right. Everything okay up to now? Come to the section 219 of the Indian Succession. Indian Succession Act 219 emphasize importance over if deceased died intestate and not belong to the class of section 218. Who are the person who belongs from this class? Hindu, Muslim, Buddha, Sikh, Jain, or any person including in it. So if the person not belonging from section 218, then section 219 is mentioning that after the death of the owner, the legal heirs, executors, or the beneficiary of the property of that owner will go to get a probate or letter of administration. Under 212, it is specifically mentioned under 212 in the same act, in 212 too, that Hindu, Muslim, or the person belongings from 218, section 218, or the class of the 218, they are not bound to obtain this certificate, but due to some Supreme Court judgment, it will become a formality for execution of the will. I am talking about intestate. I am not talking about testamentary. I am specifically talking about the intestate. Come to the section 222. Who will move the application for this? Sorry, section 372. Who will execute the application for this? The beneficiary, the executor of will, and so on. It is in the basically part 10 to move on an application. You can move an application in the court of district judge or any type of competent authority, which in future, if suppose the government is going to change the legislation and making another tribunal for execution of will and related to the wills, then you will go for it. But right now, the stand is regarding district. Come to the consideration. This is the most important part, because whenever you are going to see the judgment, after submission there is a column which is consideration of submission. So from here the real findings of Supreme Court is started. During the consideration of submission, Supreme Court considering the findings of trial court, the findings of High Court, previous important case laws, and the finding of Supreme Court and decision. So what we are going to do deal now, these parts. What are the consideration of submission? So Supreme Court here mentioned first and foremost thing about the adverse position, that in the case of adverse position, it is plaintiff who is required to prove the plea. As it is in civil cases, the burden of the proof generally lies on the plaintiff. Under the case of the adverse position, the burden of proof lies on plaintiff, first thing. Then, in the same judgment, Supreme Court highlighted Judgment of 2021 SCC 1 M. Siddiq versus Suresh Das. It is a constitutional bench, so that's why the finding of this bench becomes law for us, especially who are the litigants. What the Supreme Court basically want to emphasize by this judgment, the Supreme Court emphasized certain points. First point is possession is adverse in the sense that it is contrary to acknowledge the title of the another another person against the true honor or against who claim it. So basically, in the cases of the adverse possession, plaintiff claimed claimed against true honor. The second thing, if the plaintiff or the person who is claiming adverse possession, what are the essential requirements? So, according to this case law, in adverse possession, the plaintiff must first prove the nature of possession, and second, character of possession. Nature of possession and character of possession. What is the nature of possession and which kind of nature of possession required to prove by the plea of the plaintiff or the claimant in this case of adverse possession? So the possession must be neque, nec claim, and nec precario. It means it is not secret, it is not forceful, and it is not illegal or whatever. But the basic thing is The adverse position must be peaceful. It must be open, and it must be continuous. It must be continuous. It is not like that for 2 years any land under the position of someone, then he left it, then again for the 10 years. No, this is not in this case. Means the continuity, the openness, and the peacefulness is the first part which is required to be proved in the cases of the adverse position. Now come to the second thing, that is character. Which type of character required in the cases of the adverse position? That the person who is in position, his position must be known to public as well as to the knowledge of the true honor, right? So these are the characteristic and these are the natures. If anyone want to go with a plea of the adverse position, he or she is required to prove these things according to this constitutional bench case or judgment. Come to the next point. How anyone can do it? Means in the cases of the adverse position, you need to require prove nature as well as characteristic. So if anyone here is the civil lawyer, he know that before filing the suit, there are the few formalities, and the suit is starting from the cause of action as well as plaint. Plaint is an important part. What is plaint? Plaint is the pleadings of the case. So nature of adverse position, that is peaceful, continuous, these must come in the pleading. Means these points must be the part of your plaint. So adequate pleadings are required. For characteristic, to prove this, it is going to get proved when the evidence phase will come. Fine. Now the next one, if suppose in any plaint there is not proper pleading related to the first part, is the deficiency of this part can be supplied by evidence? No, it is a highlighted point. If you are lacking any point here, it is not supplemented by evidence, or if you are not able to prove through evidence, then these pleadings are not fulfill the requirement of the evidence. So both things simultaneously parallelly required to get pleaded as well as get proved in the case of the adverse position. Is it okay? Come to the next point. Now, if we are talking about the adverse position, there is also one more important case law which I want to highlight. It is also highlighted in this judgment. You will get it in the PDF also. The citation of the judgment is of 2004 10 SCC 779. The parties are Karnataka Board of Work versus India, Government of India, and others. The basic finding of this case law is that if suppose this is the land and A is owner, now this land is empty. It is not under any person's possession. It is empty. It is empty since from 20 years. Does it create the condition of adverse position to anyone? No. Fine. So non-use of property by owner, even for the long time, won't affect won't affect adverse positions title or adverse position case. But the things are changed if suppose A transfer the possession of the property even though A is the owner, and A transfer the possession to B, then from that day from that day, the right and working will get changed. Getting it? If suppose you are the owner and you are not giving it to anyone, so it is your property. There is no issue. But suppose if you are giving it to someone, then by this case law, the adverse possession. So basically, it gives us a clarity, a bit of clarity about the cases of adverse possession. Now, what Supreme Court is telling in the current judgment, that if there is a case of adverse possession, so in the plea, the four things are required to get proof. The first essential point for the adverse possessions plea is plaintiff must plead and prove. What plaintiff must plead and prove, which we covered in the nature and the character of the adverse possession. So this is the first requirement. Second requirement, plaintiff must plead and establish the factum or fact that the possession the possession is continuous, the possession is under the knowledge of the true owner. Fine. Third point, Supreme Court highlighted that plaintiff must establish the fact that when he came to possession, if not that specific date, then at least a specific year. If suppose you are in the possession since from last 40 years, so what was that year, you must know about it. If you are in possession and you are taking a stand that I am in the possession since from 1960, then afterwards you are taking and stand about that I am in the possession since from 1950. No, it will create a confusion, and it is not according to this judgment, it is not the correct case for adverse possession. Now, the fourth and important point, the possession must open and undisturbed. So it is the requirement in the case of the adverse possession if plaintiff want to plead for the adverse possession. After considering the avertments of the original suit means the suit which was filed in the trial court. So Supreme Court, after seeing the real avertment of the trial court suit, Supreme Court find that the plaintiff claimed that he was in the possession since from 1950, as well as in the evidence it is proved that the owner of the property was died in 1947. So the owner died in 1947 and the plaintiff came in possession in 1950. Is it the correct case? No, because the possession is again the first point, that the true owner must know about the possession. So Supreme Court highlighted that according to this point, the plaintiff is breaching first point. That's why it is not the suitable case for the adverse possession. Come to the second point. It is also highlighted that that the that the trial court and high court finding, trial court highlighted that the property tax of that land, water tax of that land, and all these bills are still on the name of the owner. So that's why the mutation was not occurred. So still the true owner was that who died in 1947. Next point, even plaintiff not paid plaintiff not paid a single tax until 1995. Why he starting paying in 1995? Because he go for a civil suit. So since from 1950 to 1995, the plaintiff not even paid a single tax. Water and sewage tax also were not paid since from those years. That's why the plaintiff is not a right capable claimant under the adverse possession plea. Also, Supreme Court referred a point of High Court that in 1995 plaintiff filed a complaint, and in this complaint plaintiff admitted that he was under possession since from last 35 years. It means by this the plaintiff is claiming that he is under possession since 1960, and during evidence and in the plaint which was filed in the trial court, he claimed that he was under the possession of 1950. So due to this attitude, Supreme Court rejected the plea, torn out the remedy of adverse possession, and ordered to empty that land. So this is the good judgment, and which I personally like it because there are the many concepts which are get cleared by this. If there is any doubt or whatever you want to know furthermore, you can comment me in the comment section, as well as please download this judgment. Okay, so this is the complete judgment. Go through it. It is 13-page judgment. It will hardly take 30 minutes to you, but it will give a glimpse as well as a good source of knowledge. So thank you. Let's meet in another video with some other judgment. Thank you so much.